That matter's ready.
All right, we're here on a motion to compel. And there has been nothing filed in response for a super long time. So what's going on?
Your Honor, Roy Clay for David Gross. I believe the issue, from my understanding, is our client has some health issues related to a cancer diagnosis. I think that's basically been the continuing problem for these delays. At this time, Mr. Gross has informed me that 3 weeks should be sufficient for him to get the answer, get the answers completed. But I can inform the court that that's the primary reason that there's been these delays for this amount of time.
Ms. Bliss?
And in Your Honor, excuse me, as contained in my client's motion, Mr. Johnson was served with our initial request for discovery back in November of 2022. I was sympathetic to the fact that he was having some health issues. My client has reported recently that it wasn't a cancer diagnosis, but nevertheless, he does have some significant health issues, which is why I've let it go as long as we have, as contained in my motion in March. Mr. was the primary financial provider throughout the party's marriage. We need those records in order to finalize this matter. So I've continuously set this over. As Your Honor can likely see on the record, it was initially set back in March, then April, then May. My last correspondence with Mr. Gross was on May 31st. He requested a 3-week continuance in hopes that he would be able to gather that information. And to date, as Your Honor reflected, there's nothing been filed, and my office has received nothing for purposes of discovery. We're just simply trying to get this case moving along, and unfortunately, it's taken this motion finally being brought before the court to be heard. So we did ask for some relief within our motion. We were asking for $1,000 in attorney's fees. I outlined in there the various discussions prior to March that took place, 2 different CR26I conferences, several emails and telephonic conferences with Mr. Gross. And since then, there's been several others. So I do believe that our request for $1,000 is more than warranted, at least in this regard, as we have spent significant attorney's fees just attempting to get this information. We are also asking that a timeline, a drop dead date of, I had initially requested 7 days. I'll defer to the court as to a timeline that Your Honor believes is appropriate, but we need to get some information to keep this case moving forward. Like I said, discovery's been pending since November. Instead of responding to my client's request for discovery, Mr. Johnson's attorney took upon himself to send my client's discovery requests in the process. So this is simply just a delay tactic, and we're simply asking the court to grant our relief requested and let this matter move towards finalization.
All right, thank you.
Your Honor, can we respond to that?
Sure, briefly.
Your Honor, I would object at that point because nothing's been filed, but I'll defer to Your Honor's ruling on that.
Briefly, Mr. Flay.
Thank you, Your Honor. And to just clarify, I don't think Mr. Gross filing discovery in response is an attempt to delay anything. It's more just to make sure both sides are fully vetted. Mr. Gross has also informed me that he does have the materials now and he's just processing them. They should be out of our office as soon as possible. It's just a matter of, again, the health issues ongoing with our client and receiving them, and now being in trial today and preparing for that trial. Obviously, it's difficult to maintain both those things. Understandably, it's delayed, but we would ask that the attorney's fees be denied. Again, we're asking 3 weeks extension on discovery, but I think it'd be very possible for us to get it out within a week or so. So again, I don't think attorney's fees are necessary, given that we do have the discovery now in our possession. Just needs to be processed. Thank you.
I don't think a 7.5 month delay in discovery is appropriate. So I'm going to grant the motion to compel. I'm going to order that the discovery be submitted within 1 week of the entry of this order. So 1 week from today. And I am going to grant the $1,000 attorney's fee request. It seems that a lot of work was done by Ms. Bliss, really just spinning her wheels for your client to just, I acknowledge the health concerns, but this isn't a Mensa questionnaire. So those need to be submitted, and I am going to impose the $1,000 due within 60 days, after which it'll accrue 12% interest.
Your Honor, just adopting my March order.
Yes, I just changed the
Due date.
submitted within. Yes. And do we have Michael Fisher?
Very good.
Thank you.
Yes, Your Honor.
All right. Thank you.
Will McLean appearing on behalf of the petitioner, Alina Fisher.
All right, and I see Ms. Height here. I'm assuming everyone's reviewed the report that was filed,
Yes, Your Honor.
and we are on for a review hearing and that final GAL. So, and Mr. Fisher, I just want to confirm you've received Ms. Height's report as well?
Yes.
Okay.
Oh, wait, the final GAL, I haven't, I've been in contact with Ms. Height, but I don't think I've received any final GAL.
Looks, I had a signed copy around the 8th of June, 2023. So it's just a couple weeks ago.
Oh, well, I must have misunderstood, but yeah, I have been in contact with her and got all information back and forth between me and her, so.
Okay, so it was just a looks like a 5-page report is what I have.
Okay, yeah,
Does that sound familiar now?
yes.
Okay, all right, thank you. Okay, Ms. McLean.
Thank you very much, Your Honor. So we did also receive this informal information to the Superior Court submitted by Ms. Height. Obviously my client was very concerned by the initial report and recommendations from Ms. Height, particularly since Ms. Height had not had contact with any of my client's witnesses at that point. Even though she's been involved in this case, I believe since February. So it's concerning that my client's witnesses, including the older biological children of Mr. Fisher, had not been contacted from what I understood prior to this informational report being submitted to the court. My client is very concerned about the conclusions that are drawn related to the suggestion that she has mental health issues because of her versions of the events being identified as so troubling by Ms. Height. The concerns that I have are clearly there is confusion in the allegations and the information that's coming from my client, and or a biased belief that Mr. Fisher's version of events over my client's claims should be believed. We're concerned about the lack of communication with my client's witnesses and apparently the lack of review of the prior protection order and the declarations that were submitted both in that case as well as in this case. At least from my communication with Ms. Height, apparently there was communication and interviewing of Mr. Fisher's witnesses. It sounded as though those individuals were primarily work employees or workplace employees. And obviously individuals that you have contact with in a workplace are significantly different than individuals who are within the four walls of a household. Private lives within a household are often portrayed very differently than the public persona. And you have 3 older children of Mr. Fisher's who have lived substantial emotional, verbal, and at times physical abuse by Mr. Fisher. The suggestion that we should start any type of visitation between these young children and their father, who has been abusive to his older children, and who at this juncture has had no contact in the last 9 months. And despite my client's claims and the concerns that have been raised, both in the protection order as well as in this case, he has failed to attempt to even address any of those concerns by my client, regardless of recommendations from a guardian ad litem. We have at this point a protection order in place that prohibits him from having contact with the children. We have a restraining order in place in this dissolution action that prohibits him from having any contact with the children. And those are both predicated on the mental health, domestic violence, and substance abuse claims that were either testified to by my client and witnesses at the time of the protection order and or supported in this action itself. We already have verification that Mr. Fisher is not complying with court orders. You've already entered a finding of contempt against him for him failing to comply with the financial provisions of this order, which clearly could be indicative of his ongoing domestic violence against my client. You've also found him in violation of the restraining order by attempting to have contact with the children by sending gifts to one of the children, again, which could be construed as an ongoing cycle of domestic violence. You have 3 witnesses in these older children, my client, as well as, well, I guess it'd be the 3 children and my client, who have specifically testified about events involving Mr. Fisher killing animals in front of the children. And what he has done is, apparently he has attempted to confuse Ms. Height with the actual factual information. You see sort of the frustration in his youngest daughter's declaration, where she talks about the fact that there's 4 cats here that he has contrived in this report to Ms. Height, in the suggestion that he hasn't actually killed a cat in front of Emily, the middle daughter. The suggestion, the factual suggestion and information that you have supports that Mr. Fisher is a dangerous individual. He is a domestic violent individual. And as we know, killing animals has a high proclivity for domestic violence. And also concerning is the fact that you have 3 older children who have absolutely 0 relationship with their father. And there's a reason for that, because he was abusive to them emotionally, physically, and it's highly shocking to have a guardian ad litem suggest that there needs to be visitation started when we have no evaluations for Mr. Fisher. We have no attempt to communicate with those witnesses. And it is just quite concerning, particularly when we have this ongoing evidence that he's continuing to attempt to abuse my client and violate court orders. There is not one shred of evidence contained in Ms. Height's initial informational report to this court that would support a finding that my client is, that she has a substance abuse problem, that she has a mental health issue. The reliance apparently on suggesting that my client needs to undergo a psychological evaluation or a mental health evaluation is based upon Ms. Height's confusion of the factual incidents. For example, she says, well, it's clear that this animal, this cat, or that the neighbor's dog is still alive. We agree, the neighbor's dog is still alive. It's the fostered, or not the fostered, but the pit bull that they had received that Mr. Fisher went out and shot point blank in front of one of their children. And again, the suggestion is that, well, none of that's true. The dog's buried in the yard. You've got other witnesses who identify that. You've got a photograph of a bullet that's hit the fence. It is frightening to think that a victim of this proportion is being pigeonholed in the respect that this report has suggested at the initial outlay. So our concern is, one, we absolutely do not believe it is appropriate for these children to have any type of visitation with Mr. Fisher until he undergoes appropriate evaluations. We think that those need to include a domestic violence evaluation with a state-approved provider with input from my client. We believe he needs to undergo a substance abuse evaluation with input from my client. And we also believe that he needs to undergo a psychological evaluation with parental risk components, again, with input from my client. It's telling that you saw within, I believe it was within Bethany's declaration, about the history of Mr. Fisher's own childhood. Often, how an individual is raised is a good indication of how they're going to raise their own children. And his history is fraught with substantial concerns that he himself was not raised with appropriate parental abilities to raise children. He has not filed anything in this case other than a response to a petition. He's never filed a declaration. He's never outlined any concerns relative to my client of supporting a claim for 191 factors. And this is simply a way for him to attempt to use this court system to continue to abuse my client. So we're asking that the court require him to participate in those evaluations, deny the suggestions that there should be any type of visitation, and deny that my client has to participate in any type of evaluations. There just simply is no factual evidence to support that, other than the severe confusion and manipulation of the facts that my client has brought out, which have been supported by the children who were there to observe those things.
All right, thank you. Mr. Fisher? Any response?
Yes, Your Honor. Yes, Your Honor. The witnesses, first of all, the witnesses that I've given Ms. Height I believe there was one person that was a work colleague. Other ones were Alina's childhood friends, family members, people who lived on the property with us for years. My ex-sister-in-law, she lived on the property with us for years and was actually in a physical fight with Alina. There's all kinds of things that happen. The picture that's getting painted is not accurate. I was never found. You never has spoken to me that I know of that said that delivering presents for Christmas or for my son's birthday made me in violation. If I remember correctly, you said I wasn't in violation for that. I didn't do it myself. The first time my uncle delivered them, and he always had a good relationship with Alina and the kids. And the second, for Apollo's birthday, which was May 15th, I had ordered stuff online and had it sent directly from the purchaser to their house in his name, just because I wanted him to have something from me for his birthday. I don't see how that's me abusing anybody. I just wanted to get gifts for my children. So you had said before that they could call me if they wanted to. You never ordered that they have absolutely no contact with me. You said I could have phone contact with them if they initiated it. There's the things that she's saying right now. It doesn't make sense based on what we've talked about before. I've been given as much information as I can to Ms. Height. She has a release of information from all my medical and mental health records. And I also did a release of information to the court. So those are everybody can have those and look at those. Allegations of my drug abuse, and it was allegated that that the VA has a record of my drug abuse. It's absolutely a lie. My doctor will attest to that. It's everything I'm on is highly regulated, and I've always complied with absolute strictness everything they've given me. And my mental health provider can be in contact with anybody and with the court or anything. I've signed the releases of information, so I have nothing to hide, and I'm not trying to manipulate anybody. As far as that pit bull that was shot, yes, I shot a pit bull who was actively attacking our other dog, ripping its face apart bloody, and I had to stop that attack because it was very aggressive. And that is the only animal I've killed on the property. And my children were not watching that I'm ever aware of. This is new to me. So I live on a farm, and if we have an animal attacking another animal, you have to stop it. Sometimes it takes extreme measures. I never killed any cats in front of my children. I don't know where that's coming from. I do know in my heart that Alina has said I cheated on her, and my daughters, they hate that with a passion because their mother did it to me. And if they are angry with me, maybe that's where some of this stuff is coming from, because I don't have no relationship with my children. Bethany has contacted me. She's angry with me, but she's contacted me. Emily wished me happy Father's Day, said, I love you. I hope you have a great day and get to do something you like to do. It's just not true. Guinevere hasn't spoke to me, and I haven't been allowed to see my kids for 9 months. That's why I haven't seen my boys for 9 months, because I haven't been allowed to. Not because I haven't made any effort, because every time I've made even the slightest bit of effort, I've been told I was abusive or that I'm violating something. I don't think that you get to say that and hold me to that and then turn around and say it's to my fault either. So I don't understand what Ms. McLean is talking about when it comes to that. It seems very confusing to me. So, I mean, you can talk to Ms. Hyde about all the information and the witnesses I've provided and information. I've been very compliant with that, and I have responded. I'm not a lawyer. I don't know how to go about making declarations and doing things a legal way. I can't afford a lawyer. I just spent 18 days in the hospital with septic shock. So that was from May 2nd to May 18th. So I had a little bit of time in there where I was really sick. I'm still being treated outpatient for that. So the fact that I missed the last court date, that's my fault for not knowing when it was, but I don't think the history of me coming to court and showing up will show that that's a regular thing for me. I absolutely don't want to miss anything. All this was started while I was unconscious in a hospital bed after getting hit on my motorcycle by a truck. I mean, I wasn't even awake for these allegations when they started. You know, I don't even, I just feel blindsided, and I feel underrepresented, and I feel like someone is angry with me, is trying to make me seem like something I'm not. So I'm going to comply with anything you ask me to do. I'll do any evaluation you ask me to do. I have no problems with any of that. I would do it as fast as I can.
All right. Thank you, Mr. Fisher. I appreciate that. One thing I do want to say, so this was on for a final GAL report, and Ms. McLean corrected me. We don't have a final GAL report. We have information to Superior Court and a request for direction. So, and I think I refer to it as the final GAL report. So I just wanted to correct that for the record. I'm going to give Ms. Height an opportunity if there's anything that you would like to say, and then I'll give Ms. McLean one more opportunity, and then we'll go from there.
Thank you, Your Honor. As you have heard this afternoon, I provided this report as a way, I guess, to express my dilemma that you have heard pretty fully explained here. And then also, the court had recently said they would like to know if there was going to be a delay in a final report, and I wanted to let the court know that as well. There are two other things that I wanted to make clear in this document that I filed for you. One is what you've clearly heard this afternoon, is that there are two diametrically opposed views of the information that I was receiving. On the one hand, you know, a picture of a dangerous, outrageously cruel and angry individual. And then when I began to investigate on the other side, there was a universally 180-degree difference in the information. Some of it was confusing, but some of it was very clear that this person who was described in one way is now described as helpful. The guy I always go to when I need help. There were family members, there were various other sources, as he's mentioned, that he had received promotions at work, that he was great with kids. I love it when he comes over and visits with my kids. There were just numberless quotes of a very positive nature. Since I filed this information to you, I have continued investigating. I've probably done, I should have counted up 10 or 12 more interviews, and the information I'm receiving continues to fall in these two distinctly opposing places. So in my search for independent information, I decided to ask the court to authorize some more clinical evaluations. I knew there would need to be some discussion on that. My third concern, which has already been mentioned here today, was the length of time the boys have not had contact with a parent, and that is concerning to me. In my document that I filed, I would like to make an adjustment to that. That statement was, I would like to have some non-professional. I wasn't clear on what I wanted as visitation, and after doing more review, talking with various other people, what I would really like to express to the court, I do believe these children need to have contact with both parents, and I would request that the best way for there to be an evaluation of that would be to have professionally supervised visits. There would then be notes for that. Also, I could observe one or more of those visits. I talked with Ms. Beth Fellows at Reconnecting Families and just gave her a very brief sketch of the information I was looking for. And what she suggested was that the court consider, rather than a 2-hour visit, a 1-hour visit twice a week. She thought that would be more beneficial to get information. She also speculated that the really helpful information that would come out of those would likely not occur until the second and third and weeks beyond the first one, that it would take some time after this many months away from their dad for the kids to really be comfortable in that setting. So I feel like visitation in that setting would be safe for the kids, and it would be appropriate for them to have contact with both parents. So I also reluctantly am thinking, depending on what your honor wants to do as far as requesting evaluations, I think probably August 15th is going to be the earliest and optimistic date to get information back in. There were, just to circle back very quickly, there were competing allegations on both sides about drinking, about serious drinking, about verbal abuse, about anger, about who's the isolationist, and of course, all of the animal things. I did speak with, well, I'm not going to go into who all I spoke with, because a much more detailed report representing the other investigations and declarations that I've had access to will be forthcoming, and I don't think it would be worthwhile to get into those without some written documentation before all of the parties today.
All right, thank you. Ms. McLean?
So contained within Ms. Height's report, as well as within her oral presentation here today, there is absolutely no information as it relates to Mr. Fisher's relationship, involvement, etc., with the children. She's talked about employment. She's talked about other children. She hasn't talked about his relationship, his historical role with these two children, his historical role within this household. There's absolutely no information. And at this juncture, we're over 9 months since he's had contact, or I'm sorry, we're nearly 9 months since he has had contact with his children. You also have no evidence because it doesn't, it's not available because the children have never called him. The children do not have a connected relationship with him. They have not reached out independently to call him during this time, even though there is a court order that if they want to have child-directed phone calls, that they can. Realistically, I think we're attempting to put the cart before the horse. He needs to address his parenting deficiencies and his domestic violence before we expose him to these children. The suggestion by Ms. Fellows to put him into supervised visitation before he's addressed those issues, again, I think realistically, we're looking at the need for a reunification counselor once we determine that he has rectified those parental deficiencies. So supervised visitation is only going to make things worse if the children are not ready for that. I think we heard that from you in a case earlier today, where you said, look, if I order visitation now, I'm putting dad in the bad guy position. Well, I think potentially that's the same for this case as well, because you have children, if in fact you believe what Ms. Height says is the one dichotomy, that this is a dangerous and scary individual, then those things need to be resolved before we can have a healthy relationship and move forward with healthy supervised visitation at all. So that's my concern, is that I understand that Ms. Height is trying to make things all rainbows and unicorns, but that's not the world that we're dealing with this case. You have substantial evidence from witnesses that supports that he's the scary guy.
Might I briefly just clarify one thing, Your Honor?
Sure.
I know it's been a long afternoon. In my final report, there will be some information that I've received from family members, from people who have had contact with the family. It's information that came after I put this document together that described Mr. Fisher as a good parent, as somebody who did activities with his kids, that his therapist spoke about some of that he had some information about. None of that is in the report, so it seems shallow. But I did want you to know that I did have some information that made me feel that there is a relationship there that is worth trying to salvage, and that these children need to have contact with both parents. And I don't believe that's rainbows and unicorns, but I think that's just real family life.
Thank you. The court's in a very difficult position. I mean, frankly, in family law in general, the court's in a difficult position because you're splitting Tupperware between parties that often aren't seeing eye to eye. You're getting snapshots of a family life with no real complete and total understanding of everything. Court's never fully aware of everything that's going on. What I can say, Mr. Fisher always sounds like a polite, nice man when he's at court. I have declarations under oath and allegations under oath about a lot of the bad stuff. And then I have, frankly, Ms. Height saying, but hey, there is some good stuff. I hope so. And I'm glad, I'm going to look forward to hearing that. But at this point, I don't have any reason why Ms. Fisher should have a domestic violence evaluation. There's no allegations been made by Mr. Fisher of any domestic violence other than what he just said today, which really is just more informational than anything. He hasn't filed a declaration of that nature. He's not under oath when he's talking to me right now. I don't have any reason to order any substance or an SUD evaluation or a UA on Ms. Fisher. If when we get a report, there's a reason for that and there's a basis for that, more than what I've heard today, different story. The supplemental information filed by Ms. McLean with the affidavits and declarations by Ms. Bethany Fisher, Guinevere Fisher, outline some of the animal issues. It sounds, Mr. Fisher's version sounds completely reasonable. Dog fights are terrifying and you want to end them as quickly as possible. It makes perfect sense. The other versions of that incident are tragic and terrifying for a completely other reason. And I have those under declaration under penalty of perjury. I feel that there really isn't a choice for the court at this point other than to order the evaluations that are requested by Ms. Height for Mr. Fisher. That does not mean if Ms. Fisher we get to a point where there's some serious concerns with drug or alcohol use that the court won't consider getting a UA done or, a full panel UA, a hair follicle, something at some point. But I would ask Mr. Fisher, as part of his work with the guardian ad litem, he's indicated he has no problem with any of this, that he undergo a domestic violence evaluation. That looks like there was notes that are requested from his mental health counselor, and so a release of information to Ms. Height for those.
I also did one for the court, Your Honor.
I'm sorry.
I didn't know. I also did a release of information from my mental health and from the VA for the court. I don't know if I needed to do that, but I just put one for county court. I don't know if I needed to do that, but I did.
Probably not. I, as a judicial officer, I can't independently do investigations into any of these. So I appreciate that. I'm sure you were trying to be helpful. I don't know if that helps Ms. Height or if there was another independent one for her done.
Yeah, she had an independent one also.
Perfect. And I think the military records and VA history, medical history were part of that as well. Is that correct, Mr. Fisher?
Yes, ma'am. Yes,
okay.
Your Honor.
So I think all of those are absolutely important for Ms. Height to review. Here's where I'm at. If we can get some information, even I'll accept an email to myself and the parties from some of that, any of that. If there's a DV evaluation that's got a quick turnaround, or if we finally get the mental health counselor reports and you're able to review those and you want a reconsideration of supervised visitation, I will happily consider that. At this point in time, there was a hearing in October or November, I believe, of last year. Testimony was taken and a judicial officer ordered no contact. And unfortunately, since that point in time, we haven't heard a whole lot from Mr. Fisher, other than I think I've heard more from him today than I have since the filing of this case. So I don't know that I'm in a position to change that. Do I want to change it? Yes, I do. I want Mr. Fisher to have contact with his children in a healthy and positive manner. And I want to make sure that there's things in place to ensure that that's how it's carried out. So I will order all those evaluations for Mr. Fisher. I'm not ordering any of those for Miss Fisher at this point in time. If there's additional information that Miss Height becomes privy to, I'm happy to reconsider the few requests for Mrs.
Let me ask some clarifications.
Sure.
Is the DB evaluation to be completed by a state certified evaluator with collateral input?
Yes.
And I'm assuming that that's at Mr. Fisher's expense.
Yes.
And then I can't type today. Is the court going to order psychological evaluation with parental risk components?
No.
Okay, so I'm assuming that I'm going to be provided with copies of mental health records and whatever Ms. Height receives.
I can do a release of information for yourself if you would like.
I would rather receive whatever is being received by Ms. Height, I guess, at this point.
That's
Okay.
sure. Yeah.
It sounds like Mr. Fisher doesn't have a problem with you seeing all that. And if you want to receive
Nope.
it by way of Miss Height, that's fine.
Okay, all right.
All right.
Presentation and do you want to set another final GAL review, and if so, when?
Presentation, I'm sorry, you leave is it the 14th? When
Yes.
you?
The 14th.
I don't know that we can do presentation before you leave. I'm out the 11th through the 14th, and I'm also at the 7th. So the next available date would be the 18th. And is that still open, Miss Terry?
I'm out the 14th.
Oh, that's right. So
So
we could either do the 1st.
that would be fine.
Okay. And then Miss Height, realistically, another review, and then obviously if this needs to be noted on sooner for some other exigent issues, it can be, but realistically, how do you feel about just make sure that the 27th of September? No, I'm sorry, the 26th of September. Is that too far, or is that enough?
It's really going to be contingent on how soon we can get all of this back. It's probably, considering that I like to get my reports done in time for everybody to have 10 days or so to review them and respond, that's probably pretty realistic, actually, even though I don't like to go out that far.
I understand that we've been having a lot of delays with medical information and some of these evaluations.
Yeah.
Let's set it for September 26th, 2023, 1 p.m. If we get information sooner and things progress sooner, I am more than happy to
Noel
bump
McLean
that
on
up.
behalf of the respondent and
Thank
moving
you.
party. Right, thank you. And this is our motion for contempt and for additional relief against Mr. Chilton. This is a relatively unique situation in that we do not have an order of child support. We have provisions within a temporary order that provides for Mr. Chilton to pay his share of uninsured healthcare expenses, daycare and Montessori expenses, extracurricular activity expenses. And I guess, so is Mr. Chilton present?
No, my guess is he's watching on YouTube. That's typically what he does. Can you hear me?
Yes.
Yep.
Okay. I guess my only concern is that there is an order to show cause that's been issued in this case under the contempt. And there's typically a reason for that. So, but I guess I'll leave that to the court. So the temporary order that was entered a little over 3 years ago now, on May 13th of 2020, provided for those orders for Mr. Chilton to pay his share of those activities for the children, or those expenses for the children. My client has been consistently billing Mr. Chilton since the commencement of these temporary orders with regards to these expenses. Mr. Chilton does not deny receiving any of these billings. He does not deny that he has failed to pose any objections to the billings. He does not deny that he has failed to pay 1 penny towards what he owes right now of $21,205.52 in expenses And then subsequent to the billings that have been sent during the pendency of this action, another $235. So my client, out of her pocket, has at this juncture in the last 3 years spent over $42,000 on children expenses related to work-related daycare, not work-related daycare, schooling, private schooling that the parties had agreed to, as it relates to extracurricular activities and the like, as well as medical expenses, uninsured healthcare expenses, health insurance expenses, all of which he's supposed to be contributing. So my client has provided 100% of the financial support for these children. And like I said at the top of this argument, there is no other child support transfer payment. So it's not as if he's got a monthly support payment. In 3 years, he's paid zero for his kids. We are asking the court to enter judgments for the amounts that are owed. And as I indicated, if you add in the $235 to the proposed order that I gave to you, that means right now he would owe my client $21,440.52. And that would be, let's see. Sorry, I didn't put that date down. That would be through May 26th rather than the date of March 9. We are asking that the court reserve the determination on interest because technically child support or child-related payments that are not timely paid accrue interest at 12%. And my client should be able to make that argument at the time of trial moving forward. But clearly, he has failed to provide any of those payments. And the problem is it's also compounded by the fact that he now has not been exercising visitation. He hasn't seen his oldest child, Olivia, since August, I believe it was August of last year, which means then that my client is the one that's paying for all of her room and board, providing for all of her transportation to her extracurricular activity expenses because he's not taking her. If he were exercising his visitation, then he'd be providing food in her mouth, clothing that she might need, that extracurricular related activity transportation. He would be co-parenting as is expected and anticipated under the child support calculations and within the CR2A parenting plan that we entered. But he's not doing that. At this point, he's exercising maybe one weekend a month with Alina, his younger child. The girls have always been involved. They've always been very active girls. That is not an issue that has changed since we entered the CR2A agreement on the final parenting plan. It has been Mr. Chilton's unilateral choice to move up north. It's been his unilateral choice earlier this month to move to Wenatchee. My client didn't make those choices. She is trying to be a full-time business owner and provide money that can support her and her children. She's trying to be a full-time parent with little to no emotional support from Mr. Chilton and certainly absolutely zero financial support. So we're asking the court to enter those judgments as prayed for. My client needs financial help. This is not a strategic issue. While we have agreed to pursue this matter as a binding settlement conference, we have not set a date at this juncture. My client needs some help. So we're asking that the court order that he pay no less than $1,000 per month towards those arrears that he owes. Had he been paying as we had gone along over the last 3 years, we wouldn't be in this position. But he's the one that has made the conscious choice to take trips and to have a lot of discretionary spending rather than help support his children. So now he needs to provide sufficient payment so that my client can do this moving forward. I would also note that one of the requirements is that life insurances and the like are not to be changed. At the time that this action was started, my client tells you that the parties did have life insurance policies on both girls through the business. The life insurance policies for the girls is $134.21 per month. That is an expense for the girls. That is an expense that they as business owners decided to take on. That is something that will benefit both parties if something were to happen to either of the girls. We are asking that the court consider including within the 50% of those expenses that cost of $134.21 per month. It doesn't sound like a lot to the court, but when you're talking about being thousands and thousands of dollars in arrears and one parent trying to float this whole boat, which is going to benefit these girls and these parents in the long run. These girls are very talented. They're looking at getting scholarships, which is going to benefit everybody in the future. So we're asking that the court order that he contribute 50% of those life insurance policies, the costs for those, and include that within those temporary order expenses. We have also asked that the court consider entering that as a retroactive for the period from February 1 of 2020 through May 31 of 23. If the court does that, his 50% would be $2,415.78. And then the last issue moving forward is in regards to basically trying to preserve the main asset of this community. And granted, this has taken a long time. I think there's certainly efforts to try and point the finger at my client for delays. There have been issues on both sides as it relates to trying to exchange information. Only just with this filing did we get updated bank statements from Mr. Chilton, which were revealing, quite revealing, in fact. When you take a look at those, you see that he can't, or he hasn't explained the, $37,000 difference in his monthly deposits in 2022 compared to his earnings. So he claims that his net earnings from his employment last year was $40,138, but he had deposits into his bank accounts that totaled $77,971. And he provides absolutely no explanation for that. Some of the discovery suggests that he has his own business that he has started. Whether he's been working that on the side as well as this other employment, don't know, because it's not been forthcoming. He's not produced any documentation relative to his current employment in Wenatchee. What's going on there? We have absolutely no information relative to that. It appears, one would surmise that when you look at the September 20th or September 2022 bank statements, you see a $13,339.24 deposit into his bank account. First off, he hasn't produced any documentation relative to his life insurance policies. And my guess is because he cashed it out. And that's probably the evidence that he cashed it out. Of course, had we known that, that would change potentially our argument on asking to help save this main asset, which is this house. The parties did not appropriately attend to their roof, it sounds like. That's apparently what the insurance company has concluded, and the insurance company is no longer going to insure these folks, which is going to have dramatic ramifications on their mortgage if they do not have insurance, because that's going to put mortgage insurance, which is horribly expensive, on top of this monthly mortgage payment. As a result of the roof failure, the chimney has completely failed. My client has gone through a winter and a rainy season with the roof and the chimney leaking, and it's causing further damage to this residence. If they go to put this house on the market, that is something that is absolutely going to have to be disclosed. And clearly, we're looking at a significant issue. We've got roof bids between $31,000 and $35,000. Our suggestion is that we stop there, and then we can see if we can't patch the chimney. Although my client tells you that she does have somebody available to come out and do the chimney repair. Obviously, we're going to need to do the roof as well so that we don't have further issues. But at this point, insurance is canceling. They're not going to be renewing, and that's going to cause issues. Our potential remedy, and at this juncture, Mr. Chilton has not declared that he cashed out that life insurance policy. Actually has two life insurance policies. Our remedy was they each draw $15,000 off of their whole life insurance policies so that those can be used towards these repairs. We can determine at the time of the binding settlement conference how those are going to be applied, how those are going to be figured in the balance sheet and whatnot. But now is the time to address this before we get into another rainy season and a winter and have more damage done to the interior of this home. So that's the relief we're requesting. We're also asking that the court, due to the violations of the parenting plan and the financial orders, that you enter $500 in sanctions. If there's any time that a civil penalty is warranted, it's someone who has had ongoing monthly notice of his financial obligations to support his children, and he's thumbed his nose at this court's order for the last 37 months. Totally egregious, has no valid explanation for it, is able to gallivant all over the country on trips and whatnot. He should be held in contempt, as well as contribute at least $2,000 towards my client's attorney's fees. We have substantial time in just putting together all of the information to provide to this court and the expense Excel spreadsheet. Thank you.
Thank you. Mr. Zandy?
And I'm going to be brief, Judge, because it has been a long day and you've got my client's response to this, and there's three main issues before you. And I would start by noting that, yes, we're on the verge of going to a binding settlement conference. By all indications, that's going to be September, which is a good 3 months before the rainy season. I think we can wipe out the issue of the roof and the chimney right off the bat, because that is an issue that should absolutely be reserved for trial. This is a case in which my client hasn't been inside the family home in nearly 3.5 years. He has no idea what the chimney looks like, no idea what the inside of the home looks like, no idea what the roof condition is like, outside of information we get in this as part of this motion. I would say that does seem awfully strategic. I remind the court that Ms. Chilton has had access to this home. The only party that, to the best of our knowledge, has been residing in the home and is responsible for the payment of the home mortgage and the like. So to now suggest, well, I want the house on a permanent basis, but I also want contribution towards these costs and expenses from a partner who has not been there in 3.5 years seems extremely disingenuous. Go a step further. Again, we look at some of these other aspects of this case. Counsel states that my client voluntarily and willfully moved up north. That's not the case. The court went backwards in time and looked at how this originated. There's no child support order. There's a temporary order that doesn't order any transfer of child support, nor does it order any transfer of spousal support. I would remind you that Ms. Chilton makes roughly 3 to 4 times what my client does. I would remind you that these two owned a very profitable business in the chiropractic industry in Longview prior to the separation. They were doing very well together. Wife is now in a position where she has access to the home, access to the practice, and access to the income from that practice. So my client essentially goes up north because he had to survive. Initially, he goes to Olympia. He then goes to Port Orchard. He's on the verge of buying his own practice up there. Lo and behold, regardless of pointing fingers, Ms. Chilton was dilatory in filing for the taxes. That opportunity went by the wayside. He's now in Wenatchee. He's trying to survive. As far as these extravagant trips gallivanting across the country, again, I have no idea where that originates. That's news to me. He lives very frugally. As he indicates to you, he is in need of extensive dental work, and he can't even afford that. So this is not about him just simply thumbing his nose at the court as indicated by counsel. This is about a man who's gone from living again with a partner who had not only dual incomes, but she also has the side business from the doTERRA, in which she gets significant funds from that, losing out on that, having to relocate, having to build a practice, and having to get his own home and leases and the like for that, as well as trying to find a new job in a very specialized field. It's not as simple as him just thumbing his nose and leaving and moving on to greener pastures. That's just not borne out by the evidence. Arguments about the life insurance, again, that's an issue we can take up on trial. I didn't see any information outside of speculation about this deposit or this withdrawal, or we assume that he did X, Y, and Z. That's going to have to be through testimony and further documentation prior to the time of the BSC. And again, that can come out in a short period of time through that testimony. To bring that before the court today and dovetail that and work it in with a contempt motion, again, that is strategic, because they're asking you to do something that you can't do on the limited information based on the local rules, which only gives you a certain amount of pages and space to respond to certain items. So again, we're asking you to reserve on anything related to this house. The parties can sell the house. That would be certainly an option. But again, that's an option that needs to be taken up in the early fall when we have the BSC or the informal trial as planned. As it relates to the parenting plan, and again, my client gives you very specific information. Keep in mind, he's not the primary parent. The relocation statute does not apply to him. The only way they can bring a contempt on that is if he violated the relocation statute, and as the non-primary custodian, it doesn't apply. He was forced to go to Olympia. Ms. Chilton knew that. He went to Port Orchard. Again, Ms. Chilton knew that. He's now in Wenatchee, again, because the Port Orchard opportunity was essentially taken off the table by the doctor who's going to buy the practice from. He's doing this, again, out of necessity. Counsel is correct. These kids are very talented. These kids are smart. These kids have a very bright future ahead of them. They are also extremely active in extracurricular activities. We got one child who's 17. She's basically an adult. That's to my knowledge, she has her license. She has volleyball, which she's very good at. She has AAU. She has tournaments to the school. She has all these opportunities, and those literally eat into nearly every weekend. My client details for you, and again, this is information that's going to need to come out at the time of trial through testimony, that he takes both kids to their activities. You can't take both at the same time because one might be in Eugene and the other one might be in the Seattle area. It's completely impractical, if not impossible, to suggest that he take both kids over his quote unquote regular time, given the ages of the kids and the fact that they're participating in so many different activities. He is involved, although he might have not had the traditional overnights with the older child. Again, we're talking about a 17-year-old who's a young lady, who has a social life, who has the extracurriculars, and who's very engaged in athletics. That is certainly not a willful and intentional violation of the court order. Rather, that is just adapting to your kids growing over time, and now we're on the verge of adulthood. That is what it is. Lastly, as it pertains to the back support issues that were referenced in Ms. Chilton's motion, again, my client, he doesn't run and hide from that. He tells you, yes, I absolutely have gotten behind. Yes, I absolutely acknowledge that and recognize that. And no, it was not by intentional design or because I was intending to circumvent the court order. That's not the reality. He went from a job and went from having his own business and his own practice with his wife in Longview to having to adjust on the fly. And that's quite just simply the reality of this situation. Again, he didn't choose to be in this circumstance. He didn't choose to go through a separation. He didn't choose to walk out on a business that he worked so hard to build up and the clientele that he had. He was forced into that because of the separation. He's now in Wenatchee, and once again, he's trying to build that back up. So if you look at whatever these expenses are, again, I would encourage you to look closely at that May 13th, 2020 order. States petitioner and respondent shall each pay 50% of the following expenses: daycare, Montessori, obviously that doesn't apply anymore given the kids' ages, health insurance, uninsured health expenses, and extracurricular activities. You look at the list of items that are asked to be contributed by Ms. Chilton, you'll see that she's asking for taxes on one of the kids' phone. I frankly have never heard of that. Library fees, yearbooks, membership fees, sweatshirts, car insurance, these random purchases at Nike.com, and these summer programs, which again are not covered under the order. Again, this is an issue that needs to be resolved with testimony, full documentation in front of a court at the time of, in this case, the binding settlement conference. It's the only really way to do that. So to suggest that here we are in the last part of June with pending and very hopeful informal trial at the first part of September, to suggest this wasn't strategic, that this isn't to get a leg up on the balance sheet, in which I think everybody acknowledges she will certainly get the lion's share of the property and owe him, again, I think is relatively misplaced. That's exactly what it is. We're asking you to deny the contempt, alternatively reserve on that until the time of trial. Multiple issues presented today can't be resolved on a motion docket at 4:30 on a Tuesday afternoon. Again, that requires testimony and full information to be presented. And again, we are asking you to deny the motion or at least reserve on that pending further information, the full testimony.
Thank you.
Just briefly.
Very briefly.
Very briefly. On the House, he has not asked for independent access, even though information has been sent over the last 2 years, including bids. In regards to the suggestion that we're proposing about cashing out the community life insurance to apply those towards a community asset, I think is apples to apples versus council's argument. There is absolutely no evidence that suggests that he had to move from here to move to Olympia or to move to Port Orchard or to move to Wenatchee. He could have maintained his clientele here. He chose to move. And there's other local markets much closer and within our own market that he could have used. There have been absolutely no objections to billings, and my client explained in her SIR reply declaration the necessity of those billings, particularly the ASB and the Nike.com and whatnot, all related to those extracurricular activities. But if he had an issue with those, he should have provided those objections. Thanks.
Thank you. So there's a lot going on in this case. There's been a lot going on in this case from the beginning. I've reviewed a great deal of this case. I'm assuming this is highly frustrating for Ms. Chilton. Clearly there was a lot of work put into outlining everything that's been charged, everything that's done. The problem is we don't have an order. I don't think that really outlines everything in a very helpful or specific enough manner to encompass everything that is claimed on here. Ideally, would it be 50-50 everybody? Yep, it would be 50-50 everybody. And I think that was probably the intent of the order. There is a lot in here though, and that I tried to review and did my best to review. Long story short, I'm not going to deny the contempt. I'm going to reserve the contempt. We're not in a position, I think, both parties are employed. I don't think Ms. Chilton, sounds like there's going to be a remedy soon. And so I'm going to reserve all the issues, including the roof, to the binding settlement conference. I'm not going to deny it as requested by petitioner. I'm going to reserve it and add it to the binding settlement conference. I do understand the concerns and issues, but I think parties are in a position where they can get through. I do think bills should continue to be sent as necessary, as outlined in the order. My hope would be that Mr. Chilton would start paying that. He's acknowledging that he needs to pay a great deal of this. So my hope is that that happens. Court is, and I'm going to just in the minutes, please, Ms. Terry, make a note that interest and penalties are specifically reserved to the BSC for determination between now and then what Mr. Chilton does. If he starts making an effort, then maybe the civil penalty won't be as extreme as it may otherwise be if he just apparently chooses to ignore the fact that he has kids that actually need money to do the things that they're doing. So,
May I ask a
Can we
question?
just maybe it makes sense to just do a handwritten bench order to that effect and save the presentation date?
I'm reserved. So I have a contempt hearing order and I just kind of struck through the language in there, put reserved. And I'm happy to add in basically what I just said about, the court at the BSC, will consider what's happened between today and that BSC with regards to any civil penalties.
Okay, fair enough. Thank you.
May I ask for the ruling from the court?
Sure.
My client needs some help. So we would ask that the court set a bright line minimum. I mean, even if you suggest that these couple of issues complained about by counsel, those don't even arise, I don't think, to more than $1,000 at most. My client needs some help. We need a bright line as far as what he's to pay on a monthly basis, because we all know he's already in arrears. So we would ask that the court continue at least with the language that's at paragraph 11A, that he's to provide no less than $1,000 per month between now and whenever we have our BSC, because that will at least give my client some relief.
Well, again, I would just suggest that I think that's already been ordered upon and included in your honor's oral order today. I think that's already all encompassing of that. Again, I think there's dispute on what those prices and those costs are and what is included in that. My guess long term is this is probably going to have to be taken out of the balance sheet somewhere. I mean, that's my best guess. And I certainly get the position that Ms. Chilton needs help, and I will strongly encourage my client to do everything he can. But assuming he pay $1,000 a month when his income shows that he's making less than $4,000 net per month, again, is really not doing anybody any favors and puts him in an impossible position to do that.
And I guess my concern from the public policy standard is that the suggestion.
I'm done. So I am going to order that the petitioner pay $1,000 a month beginning July 1 until the binding settlement conference. Any additional payments will be taken into consideration when making the ruling on a contempt at the binding settlement conference. So Mr. can't just be destitute forever. He's a trained professional with skills that not everyone has. And he's, frankly, it appears though at this point that he's been shirking a lot of his financial responsibilities. So I think the very least, I will order that $1,000 a month beginning
July 1
until that binding settlement conference. And then everything will be reviewed at that point.
So are those payments due on the 1st of each month?
Yes.
Okay. And did you also reserve as it relates to the attorney's fees? You mentioned the civil penalty, but I don't.
Yes, everything's reserved. The entire contempt will be reserved. I just, I guess the reason why I commented on the civil penalty is more of a what's he do in the meantime consideration.
Okay.
Thank you.
Thank you. Good luck.
Thank you.